Your Honor, the state's not required at this proceeding to notify them of every witness they intend to call and not call. What I stated at that proceeding, Your Honor was present, is that the basis for our continuance was the cyber attack. Now, if you would turn back to base 998. Now, the defendants appealed that order of the district court to the Nevada Supreme Court.
That is correct.
Okay. And if you would, could you please read the first paragraph on page 998?
This is an appeal from a district court order denying an election contest. First Judicial District Court, Carson City, James Todd Grosz, Judge.
Okay. And now, if you would, could you please turn to base 1001? And if you could read in the paragraph starting at the word despite, down to affirmed.
Despite our earlier order asking appellants to identify specific findings with which they take issue, appellants have not pointed to any unsupported factual findings, and we have identified none. The clerk of this court shall issue a remitter forthwith, CNRAP 2, allowing the court to suspend any rules in a particular case, except for the time to file a notice of appeal. For these reasons, we order the judgment of the district court affirmed.
And then it's subsequently signed by 6 Nevada Supreme Court justices.
That is correct.
And flipping back to 998. The date of this order again was filed on,
December 8th, 2020.
and so what was the relevance of this order of affirmance to your investigation?
Well, in a sense, it would have affirmed the lower court's decision, and thereby it would have declared the winner of the election to be the ticket of Joe Biden and Kamala Harris. And secondly, it would have then made the electors for the Nevada Democrat Party to be the true electors for the state of Nevada.
So this was completed before the ceremony that was executed on December 14th of 2020 by the defendants.
That is correct.
Court's brief indulgence. Your Honor, the state will pass the witness.
Mr. Wright.
Yes, sir.
Do you need any of the exhibits? They're all over here.
Mr. Grosz, I'm Richard Wright. I represent Mr. McDonald. You have identified in the courtroom all 5 individuals, the defendants accused here, correct?
That is correct, yes.
Did you investigate their background?
Can you be more specific?
What do they do for a living?
I couldn't tell you what they all do for a living.
Okay. Do you know if any of them are attorneys?
No, I don't believe that any of them are. I wouldn't know.
Okay. Was there an attorney involved who prepared the documentation that they signed on December 14th in Carson City?
I remember seeing names that were identified as attorneys, yes.
Okay. Who would that have been who actually prepared all of the documents and sent them to Mr. DeGraffenreid?
I believe it was Jeremy Hughes,
Jeremy Hughes?
I believe.
Okay. And he's an attorney for whom?
I believe he represented the Nevada Republican Party.
Okay. Who did you, during your investigation, did you determine who actually prepared these documents? And by these documents, I'm talking about the ones that these folks signed on December 14th. as alternate electors to send to the 4 locations?
I can't remember specifically the name of the person who prepared them.
Were you present during the proffer session with Mr. Chesbro?
Yes, I was.
Okay. Do you remember what Mr. Chesbro said about who prepared them?
Objection, Your Honor, hearsay.
Response?
I didn't hear an objection.
It was hearsay from Mr. Chesbro.
I'm going to offer Mr. Chesbro's statements under the catch-all hearsay exception, because we were informed that Mr. Chesbro would be here to testify. In fact, we were told that that was one of the reasons for the continuance at our hearing in early September, that Mr. Chesbro was a necessary witness, and he couldn't make it at that time because his attorney, Mr. Langford, had a medical appointment on that Thursday. And so we were only told yesterday
Yes.
that they were not going to call Mr. Chesbro. We have 2 statements of Mr. Chesbro. One statement, transcript and recorded interview, is what I call the proffer session, in which Mr. Chesbro was interviewed by the Attorney General's office in the presence of Mr. Grosz. And the second is sworn testimony of Mr. Chesbro in his bar proceedings in the state of New York, in which the proceedings were to discipline Mr. Chesbro were based upon his conviction in Georgia. There's a hearsay exception, the catch-all, that allows reliable information to come before the court if certain indicia are met. We're going to be offering the complete transcripts of those interviews. And the indicia of reliability for the proffer session was that Mr. Chesbro entered into a plea agreement with the state of Nevada in this case. But just for background, Mr. Chesbro was initially...
I'm only interrupting because I think we need to address the admissibility of these statements before we actually go into whether or not they meet the exception under the statute. Because I have objections, obviously. I don't want to interrupt Mr. Wright, but I think we're getting a little too far ahead of ourselves here with what the contents of these statements are.
I wouldn't go
The circumstances under which the statements were made.
Well, I think he has to establish that the witness is unavailable first before we even get to whether or not the statements would even meet an exception. Mr. Chesbro is not unavailable. The state had subpoenaed him originally for the proceedings and after preparation released him from subpoena.
And they didn't tell us, and they sought a continuance because he was a necessary witness and had to be available.
Your Honor, the state's not required at this proceeding to notify them of every witness they intend to call and not call. What I stated at that proceeding, Your Honor was present, is that the basis for our continuance was the cyber attack. I did also note that there was unavailability of witnesses that we had subpoenaed. At that point in time, because of the cyber attack, we didn't have the ability to thoroughly determine exactly who we intended to call. Once we were able to gain access to all of our documents, we went through our preparation, we determined Mr. Chesbro was not necessary, and we released him. If the defense had every intention of calling him, they could have issued their own subpoena. They did not do that.
We did not do that because they said they were calling him. He entered into a plea agreement by which he would testify in these proceedings. He promised that he would proffer truthfully and testify truthfully. He proffered, it's all recorded for indicia of reliability. We didn't get an opportunity to cross-examine him. The state did. They are the ones now trying to preclude his evidence to show truthfully what happened. The indicia of reliability of his sworn testimony is he took an oath and was testified about these facts in the New York bar proceedings. I can't read that. Oh, right, unavailability is not a requirement for the catch-all exception of the hearsay.
Your Honor,
51.075.
075.
In this courtroom, is the, whoops, oh, on the left side.
Is it so good?
I'll just do it on my phone.
I think we'll read your book, the judge would raise you first.
If you can grab, in the blue books, it'll be
Your Honor,
Title
we have a book here if you'd like.
show it to defense before handing it to me.
Yeah. Is that okay?
Thank you. Okay, Ms. Engler, you'd indicated that unavailability would need to be established. It appears 51075 calls availability immaterial.
It does, Your Honor, and I think what my response to that is, it says it's not excluded as hearsay if its nature and the special circumstances under which it is made offer assurances of accuracy not likely to be enhanced by calling the declarant. Clearly, what they are trying to do is offer entire testimony from multiple proceedings, one of which was not provided to the state until yesterday at 4 p.m. That, I don't think, is appropriate for hearsay. What I think the intent behind this is to offer maybe perhaps one statement that might have been made, not an entire transcript. And additionally, what they provided us as the transcript, there's no authenticity regarding that. They provided a 5-page, 5-document Word document. I don't know who transcribed that. There's no certification. So I have questions of authenticity regarding that. Additionally, the second statement they provided to us last night at 4 p.m.
I may respond. We prepared to cross-examine Mr. Chesbrough. They never told us they were not going to call him. On September 30th, the state told us there would be no surprises when we inquired about the witnesses. And then yesterday, they said we're not calling Mr. Chesbrough. We then sent them just to make sure they had them. The transcript is of the interview she conducted. This can be no surprise. They didn't prepare a transcript. We prepared a transcript of the proffer session. We sent both and gave her notice that we intended to introduce them since they hoodwinked us on Mr. Chesbrough.
And Your Honor,
In the proffer session, is there a fair argument, Mr. Wright, that those are arguably self-serving statements if he's curious whether or not he's in trouble for doing something?
No, he was proposed to be indicted. He was in the indictment. He received the Markham notice, okay? And he then agreed to cooperate and testify against these individuals in lieu of him being prosecuted by Nevada. He entered into a cooperation agreement by which he would not be indicted.
Did he, so those are self-serving, so the condition of reliability raises some questions. You mentioned you weren't able to cross him, but arguably the state had some ability to cross him. Was he crossed by either in any judicial proceeding or in the last grand jury? Well, grand jury, there wouldn't be a cross.
Right, well, he did testify at the grand jury. Also, he testified at the grand jury. And it wasn't self-serving, he had immunity. And he was obligated to tell the truth to keep his immunity. That's in the plea agreement. This wasn't him trying to talk himself out of being prosecuted.
Mr.
And the
Justice,
state has, I mean, we're the ones giving up the right of confrontation. The state doesn't have any right of confrontation. We're saying, since you pulled the rug out from under us without any notice, after telling us you need a continuance because he's unavailable, we said in the alternative, rather than asking to continue it so we can get him here, we'll just use your interviews of him, which they vouch for the credibility of.
Mr. Chesbrough, a resident of Southern Nevada?
Puerto Rico, as I understand it, they would know.
I believe that's where he resides, yes, Your Honor. And he does have Nevada counsel that they could have contacted. I mean,
We
the
contacted.
state, I would like to reiterate, it's not the state's obligation to provide the defense with the list of witnesses and exhibits, for that matter, for a preliminary hearing. We did provide the exhibits in advance. We did notify of who we intended to call yesterday morning so that they had an indication of what we were going to do. I will reiterate, the basis for our continuance was the cyber attack. That was what the affidavit stated. Under oath, I did provide the court additional information at the direction that we did have witnesses that were unavailable.
One was the national archivist.
Correct.
And then the second, I do recall bringing up the subject of
That's correct. I did mention that Mr. Chesbrough's attorney was unavailable. We hadn't made determinations at that time whether or not we were going to call him. And we can change our minds. That's the part of being the state. We get to decide how we present the case. On the flip side, they can present the case how they want to. They could have subpoenaed him. I can assure you if they would have contacted Mr. Chesbrough's counsel, he would have accepted the subpoena on his client's behalf. They did not do that. So now they don't get to
That's
come.
not true.
I'll let you ask those questions. But it's not this, it's now they should not be allowed to now emit wholesale statements from a transcript again. I don't know if that is an authentic transcript. I was provided it yesterday at 4 p.m. I haven't had a chance to review it, compare it to the audio. I don't know if it's the truth, okay? And it's not certified by anything, it's a Word document. The second transcript that they provided is from a civil proceeding with the State Bar of New York that occurred in December of 2024. I haven't had a chance to thoroughly review that, so I don't know the veracity or the truthness or what's contained in that statement. So for them to show up today and say, oh, we were surprised that he's not appearing, They can put on their case how they want to. They chose not to execute any subpoenas. That should not then be the fault of the state.
Thank you.
We
Mr. Ray.
didn't show up today, we got sandbagged, Your Honor. Put it any way you want it. September 30th, they said no surprises. You don't think this is a surprise? They tell us Chesbrough is a necessary witness. You asked the question on the unavailability. Were these necessary witnesses, Miriam Vincent and Mr. Chesbrough? And the answer was yes. And now they tell us yesterday, oh, we're not calling Mr. Chesbrough. We're the ones that get the short end of the stick here by having to use uncross-examined sworn testimony of Mr. Chesbrough. What I wanted to do initially is examine this witness about his investigation. He sat here and explained how he investigated it. Part of his investigation was sitting with the proffer during the proffer session and learning who, how, and why those documents were prepared. That's in the statement of Mr. Chesbrough. He was there and heard it. She was there and heard it. I have not just the transcript, I will, on the thumb drive, I have the actual interview of him. So there's no question as to authenticity. And he can't say anything untruthfully or he breaches his plea agreement. And it fits within the hearsay exception.
Your Honor, they have every right to put Mr. Chesbrough on the
No,
stand.
I agree with that. I agree, in principle, the state has no duty to file a notice of witnesses, to call any particular witness or every witness in the case at a prelim. Both sides need to be prepared to present their case. Mr. Wright, on behalf of the defense, is indicating that as little as 2 weeks ago, he received some sort of assurances that Mr. Chesbrough would be here, so he forewent that. Is there anything?
That's not accurate. When he keeps referring to the surprises, and this is probably the issue with a written communication versus oral communication, what I meant by that is that there was nobody that hadn't already testified previously. I'm not bringing anybody new. So you can expect that my witnesses, who I'm going to call, you would have already had transcripts for. I did not say I was calling Mr. Chesbrough. Those words never came out of my mouth in written or oral form. On record, I said that we had subpoenaed him previously and he was unavailable for that preliminary hearing. At that time, he did not have access to any of our documents. So I didn't call off or make any final determination of witnesses. I subsequently did that and we released Mr. Chesbrough from his subpoena in early October.
We didn't know that. And
For a little context, Mr. Ray,
Yes.
Where are you headed with this? My assumption is that this is going to the issue of intent, legal advice by an attorney as to what they were doing. Someone else prepared it. Obviously, if they signed it, they're adopting, the contents of it.
correct.
Is that where you're headed?
Yes, on both portions. But number one, they were handed these by attorneys. And number two, the reason for why they were doing it, using the state's words, Mr. Chesbrough was the architect of this plan for states where contests were going on to submit alternate ballots like they had done in Hawaii during the Kennedy election. it will explain the motivation and purpose. And Mr. Chesbro testifies to all of that.
Okay.
And also, Mr. Chesbro's attorney won't talk to us.
Your Honor, if I might add too, the witness said that he was investigating to establish production of the documents. So clearly we should be allowed to ask the investigator additional questions about his other investigation regarding who actually produced the documents in issue.
I don't think they're precluded from asking what Mr. Grosz did through his investigation or what his belief or what he did. Where the state's objection is when they're asking him what Mr. Chesbro said. That is clearly hearsay, and I don't think that they meet the objection. And for the purpose that they're stating, it sounds like they're making an advice of counsel defense. I think that's where they're going. I don't want to speak for them. But when we say the word defense, those are questions of fact for the jury. This is a probable cause hearing. We are to determine slight or marginal evidence. These seem like the appropriate things to be raising at the district court level.
Sir,
Hang on a second. We have another counsel standing on this issue.
Your Honor, we're back. Sorry. I sound told. I apologize.
That's right.
Sir, I'm not asserting the advice of counsel defense before the Justice Court. I want to put on the truth about what happened. And the truth about what happened, they have in the testimony of Mr. Chesbro.
So as an additional offer of proof, if I heard this from Mr. Chesbro, he's saying that between the Supreme Court ruling or district court ruling, he still believed he had a valid position.
Absolutely. Because he had 90 days. He was handling the litigation in Wisconsin. That's where he started. Judge Troop was from Wisconsin. All this comes from his proffer. Wisconsin had a contested election going, a contest going on to the election. He prepared the same type of documents there, including the fact that to have an alternate slate, it had to be, you voted on December 14th to make it valid. And so if there was...
Is that the general timeline for any elector, whether it's,
every,
call it normal or alternate?
every single state has to do it on December 14th for 2020. I mean, it's laid out for the 2020 election. Every state had to have their electors on December 14th. Here in Nevada, the Democrats met on December 14th and cast their electoral votes and sent them all in, which were there in the exhibits. Mr. Chesbro did testify and has stated that what he did was he was then asked by his client, which was the Trump campaign, to prepare documents for the other states where there were contests taking place. He prepared these documents.
That makes it reliable in the Nevada case because the underlying person who wants to be president directed Mr. Chesbro to do something, that these are, or wished Mr. Chesbro to do something, that these documents or his testimony is reliable?
No, I'm telling you what he did chronologically that he will lay out.
Okay.
There will be a memorandum which he wrote and sent, which will be introduced. It's one of the grand jury exhibits. We'll introduce the exhibit. He wrote a memorandum.
Okay, so for now, I want to digest this. I'm going to sustain the objection temporarily. It's clearly hearsay. These special nature and circumstances under which it was made, I need to thoroughly ponder. So I'm going to sustain it for now, and we can readdress it after lunch, and that'll give me a time to analyze it. So continue with your cross of him absent underlying statements of Mr. Chesbrough.
Okay, I can ask him about the proffer, or I can't.
Not about the contents of the proffer. You can ask him if it was a proffer, what he did based upon that. But the contents of Mr. Chesbrough's statements are off limits until I digest and think about it further. And I said I'll do that during the lunch hour.
Okay. So you, during your thorough investigations, you were never able to determine who prepared the documents and emailed them to Mr. DeGraffenreid, correct?
The documents were altered.
I didn't ask if they were altered. I said, during your thorough investigation, were you able to determine the name of the attorney who put together the package of documents and sent them off to Mr. DeGraffenreid?
Your Honor, I'm going to object. It assumes facts, not in evidence. They're talking about an attorney. He hasn't laid the proper foundation.
Restate your question again.
Strike the word attorney.
So state your question loud.
Who prepared the documents and sent them to Mr. DeGraffenreid?
I believe Kenneth Chesbrough prepared documents.
Well, now you remember it was Chesbrough and not the previous person you said. Right?
Who did I say prepared them? You said the previous person.
What was that earlier name?
Hughes.
I never even heard of it.
Jeremy.
Oh, Jeremy Hughes, excuse me. Jeremy Hughes.
Okay, so which was it?
I believe it was Kenneth Chesbrough.
What's that going to be, defense what? A, defense A proposed. Approach the witness?
Yes.
Your Honor, the state's going to object to this. It was used in grand jury, however, the authentication for this document was not Mr. Grosz. So the state objects as to authentication.
Let's see if Mr. Grosz can authenticate it.
You presented this in the grand jury. Are you telling me it isn't authenticated?
The witness who,
This is the grand jury exhibit.
Hang on a second. Mr. Wright, was
Your Honor, without going into the process of a grand jury, but as you know, the state is the judge, the prosecutor, and the defense in a grand jury proceeding. So we often put on evidence, more evidence potentially, exculpatory evidence potentially that might exist at a grand jury because that is our burden. That is not today's proceeding. This is a preliminary hearing. All the rules of evidence apply. This exhibit, I believe, and I'd have to go back and verify, but was utilized through the testimony of Mr. Chesbrough. That's how this document was authenticated. So the state objects because he's not going to be able to lay the proper foundation or authentication for this document.
what's the document?
It's an email between Mr. DeGraffenreid and Mr. Chesbrough.
And was that authenticated during the grand jury by Mr. Chesbrough?
I don't know, I'll call Ms. Engler to the stand and authenticate it, that she presented it to the grand jury. I've never been in a situation where I get the document in discovery and it's a grand jury exhibit and an exhibit sent up to the Supreme Court, and now the state's saying it's not authentic.
Okay, hang on just a second. I'm looking at NRS 51035. Hearsay, and how it relates to grand jury. It's looking at subsection 2. So, hearsay, which clearly is documents being offered, I believe, for the truth of the matter, whatever's in it. It's hearsay unless, subsection 2, the declarant, here would be Mr. Chesbrough, testifying at trial, he's subject to cross-examination, so the trial meaning this hearing. And the statement is the transcript of the testimony given under oath at a trial or hearing before the grand jury. We don't have in here, are there any other exceptions to that document for now? So
Are you ruling this is hearsay?
it is in this hearing right now.
They subpoenaed and produced, there's 5 emails in there just like this, already that we stipulated to.
I stipulated, I had the custodian of records affidavit for those emails. I was prepared to lay the foundation they agreed to stipulate to them. These emails, I don't believe were contained within the Google production that is part of the custodian of records, because it comes from Jim at NevadaGOP.org, and that was not the subject of the search warrant to Google.
Is it or is it not in the full packet from the Google email?
Could I show it? Could we ask the investigator where it was acquired?
Sure.
Tell me if you've ever seen that before. I think you testified about it.
Hang on a second, he hasn't answered your question.
I can't say with any degree of certainty that I have seen this email before, no.
You recall testifying about it at the grand jury?
This particular one?
Yeah.
No, sir, I don't remember that statement.
Let me get your grand jury testimony.
Okay.
For the record, Your Honor, my objection still remains, it's still going to be here, sir, because of the authentication.
I can't hear
He's
it.
working on the authentication to see if this is where we are. I have not ruled on it.
this one.
Like, do it.
What is that, B, defense proposed B? So, I'm going to show the witness defense proposed B, Your Honor.
Has the state seen that?
Yeah, I got it from them, it's exhibit 30 in the grand jury. I gave him a copy also.
Thank you. Go ahead.
Thank you, sir.
Have you seen defense B before?
I believe I have, yes.
Okay, you testified about it at the grand jury, right?
I believe so, yes.
Okay, what is it?
It's an email.
I didn't move for it yet.
Right.
What, describe generally what it is.
An email from Jesse Benall to defendant DeGraffenreid.
Okay, is it an email chain?
An email chain, yes.
Okay, and the underneath part of the chain contains some of the same email in defense A, correct? Proposed A.
Yes. That is correct.
Okay. I offer proposed B.
Your Honor, the state does not object. It's, although not confirmed, it's likely part of the Google production since there are CCs to Mr. McDonald, Mr. Law, and Mr. Hindle.
Defense B is admitted. What's in B that I need to know?
What's exhibit B?
It's an email chain from Jesse Benall to defendant DeGraffenreid.
Okay, who's Jesse Benall?
I believe he was an attorney involved in the legal action in this matter.
Okay, and in this matter, we mean the case first before Judge Russell and then in the Nevada Supreme Court, the Republican electors versus the Nevada Democratic electors, right?
Yes, sir.
Mr. Benall was the attorney from Boston handling the litigation.
Yes, sir.
On the exhibit, if you look at the mailing of the Supreme Court, he's the attorney of record for these individuals, defendants. And so that's the Benall on this email chain.
Correct.
And if we go backwards on the email chain, meaning the first part of it, there's a December 10, I'm on page, the second page, pardon me. On the first page, that's the first email in the chain, the one from Kenneth Chesbro to Mr. DeGraffenreid.
Yes, sir. That would be where the email chain started. It was on December 10th.
Okay, and that's December 10th, 1627, subject urgent, Trump-Pence campaign asking to contact you to coordinate December 14 voting by Nevada electors. That's the subject line.
Yes, sir.
And then this is a letter, pardon me, an email from Kenneth Chesbro to Who is it to?
To defendant DeGraffenreid.
Okay, and copied CC.
Yes, Michael McDonald is copied, as is Jesse Law.
Okay, and then read the email to Mr. DeGraffenreid from Mr. Kenneth Chesbrough.
Yes, sir. Mr. DeGraffenreid, Mayor Giuliani, and others with the Trump-Pence campaign, including Justin Clark and Nick Traynor, asked me to reach out to you and the other Nevada electors to run point on the plan to have all Trump-Pence electors in all 6 contested states meet and transmit their votes to Congress on Monday, December 14th. I'm one of the attorneys handling the state court litigation in Wisconsin, the first state which made definite plans to have our electors vote on Monday. Confidentially, so you can understand how we're messaging it, below is a draft press release by our lead lawyer in Wisconsin, which would be released only after we file papers in the Wisconsin Supreme Court, following an expected loss in the lower court, which we expect to do Saturday. I'd appreciate if you or someone else on your team could get in touch with me as soon as possible. I have 2 memos explaining the rationale for the electors voting on Monday, though you may already have those. And I am preparing drafts of the documents that the electors in Nevada could sign to affect their votes, in case having drafts in hand would be of help. Call or write anytime, night or day. Sincerely, Ken Chesbrough.
And then on the second page, it has his phone number and his address in Boston, Mass, correct?
Yes, sir.
And his link page, and correct?
Yes, sir. LinkedIn is mentioned.
Okay. And then you have the proposed statement, the proposed press release that he said he's included, correct?
That is correct.
Read that proposed press release.
Proposed Jim Tropa's statement on electors meeting. As the legal proceedings arise from the November 3rd presidential election continue to work their way through the Wisconsin court system, I have advised the Republican Party of Wisconsin to convene a separate Republican electors meeting and have the Trump-Pence electors cast their votes at the Wisconsin State Capitol on December 14th. Of course, there is precedent for such a meeting. Democrat electors pledged to John F. Kennedy convened in Hawaii in 1960, at the same time as Republicans, even though the governor had certified Richard Nixon as the winner. In the end, the state's electoral votes were awarded to President Kennedy, even though he did not win the state until 11 days after his electors cast their votes. The legitimacy and good sense of 2 sets of electors proposing, let me repeat that. The legitimacy and good sense of 2 sets of electors meeting on December 14th to cast competing votes for president and vice president, with the conflict to be later sorted out by the courts in Congress, was pointed out by prominent Democrat activists Larry Lessig and Van Jones in an essay published last month on CNN.com.
And that's like a link, correct?
Yes, that is
I mean,
correct.
you could go read the essay. Okay. Proceed.
Okay. Given that the results in Wisconsin are still in doubt, with legal arguments that have yet to be decided, just as the Democrat electors met in Hawaii in 1960 while awaiting a final resolution of that state's vote. So too, the Republican electors should meet this year on December 14th as we await a final decision in Wisconsin.
Thank you. And then that, in Exhibit B, that was the email to the Nevada electors from Mr. Chesbrough. And then the next part of the chain, what did Mr. Chesbrough do with this? Pardon me. What did Mr. DeGraffenreid do with this email?
there's a statement, what do we know about Ken, question mark, is this a legitimate outreach?
Okay, and then on December 10th, 2020 at 4 p.m., Jim DeGraffenreid wrote, what do we know about Ken? Ken is Mr. Chesbro, correct?
I believe so, yes.
Okay, and so he is emailing Mr. Banal, the attorney for the electors, correct?
Yes, sir.
And then Mr. Banal, their attorney, answers, correct?
He says, I'll handle.
I'll handle. And so that's the totality of defense proposed B, right?
Yes, sir, that's it.
I don't think I prepared, that's a copy, Your Honor.
Can I see the original?
Yes, sir.
No, not the original, the one marked.
Yes.
Okay, thank you.
Yes, sir. Do we keep the defense minutes?
Let's keep all together.
Okay. I'll go back to defense proposed A. Okay? What's still proposed? Look back at the beginning of the email chain of proposed A. Looking at page what's marked as GG, page 2 of 3 of the email. Is that the same email chain that's in B?
This is part of it, yes. The part that says I'll handle and such is not present.
Okay. What it is, this email chain in proposed A starts once again with Mr. Chesbro emailing Mr. DeGraffenreid saying, we're going to help Nevada. Same as we just read in B, correct?
Correct.
And that's what Mr. DeGraffenreid forwarded to Mr. Banal, their attorney, correct?
Correct.
Yet on proposed B, on page 1, this email chain is, aside from Mr. DeGraffenreid forwarding it to Mr. Banal, and Mr. Banal saying, I'll handle, Mr. DeGraffenreid also answers Mr. Chesbro, correct?
That's what it appears, yes.
And that's what that email is.
Agreed.
I'd offer it together.
Your Honor, my same objection still remains. The proposed B would have been contained in the Google emails that we have the custodian of records affidavit for. A, I don't think that's properly authenticated. While the parties may have been the same, there is additional content in A that's not part of B. And this witness is not the author of that email, nor was this email obtained by him through his investigation. So my same objection as to the authentication of this remains.
Can I respond?
Yes.
Or proceed further and lay a foundation. You're the investigator in the case.
Correct,
Okay, and you acquired all of the emails.
correct.
And we received
Objection, Your
that.
Honor, that's a vague question, all of the emails.
Sustained.
Okay, well, all of the emails that were produced to us in discovery from the AG's office, you gathered by subpoena, search warrant, correct?
Yes, sir.
Okay, where'd you get that one?
I would be speculating a guess because it's not directly part of the Google production.
Okay, give me a guess.
Your Honor, objection.
We don't know whether it's for Mr. Chesbro or,
Well, I would object to the question. He's basically asking him to guess, which is speculation. But also, again, the proper,
I'm gonna sustain it. Frankly, even if I admit it, I've got a hearsay issue. You're trying to get in your client's response to Mr. Chesbro, and it's not an opposing party, like the state could ask about your client's statements to somebody else. So I don't see how,
I'm not offering it for the truth of the matter.
no one's being offered for.
Show what happened.
I'll sustain the objection.
Okay. In defense B, Mr. Chesbro said he would send 2 memorandums laying all of this out, correct?
Yes, sir.
And he did, correct?
There was the one from Jim Trocas, yes. But I didn't see a second one in there.
And where?
In the document you just had me review.
Exhibit B you're talking about.
Yes, sir. No, that was a press release that you're talking
Okay.
about. In the body that you read, he said, I will be forwarding 2 memos to you.
Yes, it says there will be 2 memos forwarded, yes.
And he did forward those memos.
objection,
correct?
Your Honor, outside the scope of this witness testimony. He's asking if Mr. Chesbro did in action.
Is there any indication in Exhibit B that these things were actually sent? Other than saying, I'm
No,
going
I'm
to send it?
asking the investigator if he knows that they were sent.
Do you know whether or not
I
these
don't know if-
unidentified two exhibits to the email were sent?
I don't know if he sent them, no, I have no confirmation of that.
Okay. Take your time.
Thank you.
I'll offer.
Well, but it's right here. It's right here. This is part of the statement. It's right here.
Is there-
Yes.
What's it said?
4, 7. Part of exhibit 7.
State's exhibit
It's over
7.
there.
Got them all lined up here.
Yeah.
What did you
Say 7.
7?
Thank you.
Got it?
What was State's Exhibit 7?
This would be an email chain from the Google production.
Okay. And on page 230, is there a memorandum? Don't mix them up.
Well,
From James Troopas, to James Troopas from Kenneth Chesbro, dated December 9.
yes, there is.
Can I see exhibit B? Go ahead.
I'm sorry,
Go ahead, I was just asking for exhibit B. Continue with witness.
do you recognize that memorandum?
Yes, I do, sir.
Is that the memorandum that laid out the plan for having alternate electors in the various contested states?
I believe it is, yes.
And the purpose of having the alternate electors was what?
It's my understanding, in the event of a legal challenge being successful, that's the purpose of having the alternate electors' ballots being submitted so that they could be counted then in exchange of the others.
Right. So your understanding of the memo and what was taking place in that ceremony that we saw on the video was so that there would be two slates of votes go in, and if the Republican electors in their challenge turned out to be correct or won, then their votes could be counted. Did I summarize it right?
I believe that's correct, yes.
Okay.
That's my understanding.
And that's what these defendants were doing during that ceremony.
Objection, Your Honor, speculation.
Overruled.
They were executing their ballots.
Right. And their purpose in doing it, look at page 256 of this same exhibit.
Objection, Your Honor. Also speculation. He's asking what the state of mind of the defendants are. That's outside the scope of his testimony.
So what I'm saying is, what does page 256 say?
So,
But
hang on, he's switched gears. Is your objection related to the prior?
My objection was based on what the state of mind of the defendants were, which he's asking him if
He's asking you an opinion, lay opinion on subject matter like this, given the context of Exhibit 7-230 forward, with his prior testimony. The last objection I overruled. I let it in. I think that lay opinion, for the weight that it is admissible. What weight I give it is yet to be determined.
so what I was then asking was regarding one of the Nevada electors, at least. If we look at page 256 in this exhibit, what is that?
Some communication, if I may look at the page.
Yes, sir. Yes. Or it's an email chain, so it's probably behind. Need to go back here.
You originally directed him to page 256.
From Jim DeGraffenreid to Kenneth Chesbrough. That would be the heading immediately below the section that you're referencing.
What page are we on? I apologize.
I can't hear you.
What page are we on, Rick?
He was looking at page 257.
Thank you.
Reading the email chain, it looks like this is a quote from an article out of the Washington Post. Correct?
Yes, sir.
Okay, what's it say?
In Nevada, 6 Republicans met in the capital, Carson City, to cast their faux vote before an audience of 15.
Faux, F-A-U-X. Right,
Correct.
okay.
There's still legal action pending in all these states, so what we're doing here is complying with the requirement to vote on this day in the state capitol in the event court cases are resolved favorably, said Jim DeGraffenreid.
And is that what, through your investigation, you understood they were doing during this ceremony?
Well, I understood that they were executing their ballots, but there was no legal challenge existing at that point, as it had been ruled and filed on December 8th that the legal challenges had been dismissed.
Objection, lacks foundation, move to strike.
Your Honor, he's asking for what the electors were doing. He's responding to that.
Yeah, overall.
He doesn't have a basis to understand what the status was of any continuing legal challenge. This is the basis of my objection.
Well, I'll take it in context of this particular case, that this information is likely post December 14th, and then the district court and Supreme Court challenges were previously ruled upon at least by December 8th. In this case, unknown, I'll note your objection, unknown if there was any other challenge, but in the context of everything I've heard,
Well,
it's this evidence is in.
well, we know from, you know how long the Nevada electors had after the Nevada Supreme Court ruled to file their petition for writ of certiorari to the Supreme Court.
Your Honor, objection calls for legal conclusion.
Well, if he knows the
If he
answer.
knows, it's not illegal.
Overruled.
No, I don't know how long they would have had. I know that the order was established on December 8th, and the date for which that the ballots were to be conducted and executed was on December 14th.
Okay. And so you don't know, well, did you receive, you participated in the grand jury investigation, right?
Yes, sir.
Okay. You know what a Markham notice is?
A Markham notice is to notify a subject that they are, or an individual that they're the subject of an investigation. Yes,
You know a Markham notice was sent to these folks,
yes,
and you know counsel responded to that, correct? Mr. Brian Hardy answered,
yes,
okay, and he supplied a letter and exculpatory evidence to be presented to the grand jury, correct?
I believe so, yes.
And in that letter, he laid out Supreme Court Rule 13-1 gives 90 days, and we have until March 8th to petition for cert to keep the litigation, correct?
Your Honor, again, I'm gonna call, he's asking questions about what Mr. Hardy said. Is he putting Mr. Hardy as a witness?
Hang on, I'm sustaining the objection, this is outside the witness's area of knowledge, as to how long an appeal process. If you want to tell me and ask me to take judicial notice, citing something, I'm happy to do that, but this is fruitless.
Supreme Court Rule 13-1,
One.
90 days. Well, I thought I laid the foundation. It's in the Markham letter that they received, that we asked to be presented to the grand jury. So that's why I said that you get the letter from Mr. Hardy.
Assuming that was the truth of it. So any objection to me taking notice on their offer that there's likely a 90-day window to challenge the Supreme Court's decision going further up the chain?
I have no objection to Your Honor taking judicial notice of whatever the specifics of that rule.
Okay.
So
And
how much more with this witness, just to be cognizant of the time, but I'm happy to work through the witness with you.
no, we can stop.
Okay.
So you consider that I still want to go back into it as an investigation.
Okay. We're still with the Exhibit B that came in with states that Exhibit 7 and page 256. You're going back to Chesbrough and the either proffer or information before the New York bar. Is that going to be cumulative? And where are you headed with that, or has it already been accomplished?
No, it hasn't been accomplished.
So is it a cumulative?
No. I am going to be offering, I mean, just so we're on the same page, I'm going to be offering those two transcripts under the catch-all hearsay exception.
To show what?
What happened here?
That's not a legal justification for me to hang my hat on.
Okay, it's going to show, I can make an offer of proof.
Yeah.
Okay. This would be focusing on the lack of an intent to defraud, which is an element of the charging the complaint. But they're to establish, I mean, this is where I'm going with this. Just
Right, that was what I asked a half hour ago at
Earlier,
least. And so what specifically in that is an offer of proof do you want me to hear that Mr. Chesbrough said?
Mr. Chesbrough would lay out historically how what is in the memo he came upon and how he proposed all of this, and that he did not have any intent to defraud or deceive anyone, that this casting of alternative ballots was not secret, it was known and was laid out. He started with it in Wisconsin.
So from Exhibit B and 256, back to a question a few minutes ago, why is that not duplicative? Because it's hearsay, it's further legal analysis of exact information I've already heard.
It's not hearsay, that's why I'm offering it.
So let's assume it's not hearsay, because it was said twice, it makes it more convincing to me. I mean, it's like a prior consistent statement of a domestic battery victim. I don't let every single time a domestic battery victim said something different, identical statement in.
He's going to lay out why there was never any intent to defraud and going forward, the legal basis for this. And he is going to lay out the history of how this language in the precise document that we're accused of, the state says, is a forged instrument. It's that one page, okay? He wrote that. And he's going to say it was used in Wisconsin 4 years earlier, and he used it again in Wisconsin. And then when the Trump campaign said, let's can you do the documents for the other states so we can get our votes in case we're successful with litigation? He said yes, and he put these packets together for the other 6 states. He sent them off to Mr. DeGraffenreid. Those documents that were executed are identical to what he said, other than the word Arizona was changed to Nevada to make it fit the right state. And he would testify that he never dreamed that someone would accuse them, meaning the electors who signed those, of that being a criminal offense when they were saying, I am a duly elected qualified elector. And he then explains that only the day after he sent them out, Pennsylvania received them. And the Pennsylvania delegation said, we have a partisan attorney general in this state, and if we say we're the duly qualified and elected electors in this document, he may politically prosecute us. And so Mr. Chesbro said, let's put language on your certificate, the same as Nevada's, that says it's contingent. So there's no misunderstanding by anyone. And then Mr. Chesbro lays out in his proffer session that he thought that was a good idea. So he told his clients, other lawyers above him in the Trump campaign, let's add that qualifying language, contingency, right on the face of the certificate for all of the other states too. And in fact, Arizona then came on, New Mexico, contest still going. So Mr. Chesbro prepared the documents for New Mexico, and he made them qualified on the face of it. I'm a duly qualified elector if we win our litigation. Sent those to New Mexico. 2 emails, Chesbro says to his superiors, let's add that to the others, meaning Nevada. They don't act on that, the superiors. In fact, pardon my language, in one of the exhibits, the answer to him, to Mr. Chesbro, from Mr. Mike Romans, a superior above him, was F-U-C-K down. That was the answer to putting the qualifying language into Nevada.
And that
Mr. Chesbro,
qualifying language was or was not in Nevada's ultimate language.
it was not. The actual document, I mean, just for being clear, where is it in the state's exhibits? The actual election forged document.
You can find it in multiple exhibits, 3, 4,
Okay.
7.
I wrote, this is what's alleged to be the forged instrument.
The certificate,
Yes, sir.
in which exhibit are you looking at? Actually, I believe
It's in a number of, it's what they signed.
the bottom right-hand corner is at 3036.
Exhibit 3,
It's 03028.
3028 and exhibit 3.
how does this help in any way? People in the background are saying we should put some qualifying language in. People apparently arguably above your clients decide not to put it in, and your clients decide to sign this and send it off anyway.
Because they don't know any of this exchange, Mr. They were never told, okay? They were sent these documents saying, this is the way to do it by lawyers, okay? And then the lawyers say, well, maybe this is a problem in a state where there's a partisan attorney general. And so Mr. Chesbrough would testify, says in his statement, Mr. Chesbrough says, we ought to put language in here that says, we are the duly qualified and elected voters these are my words, if we win our litigation. So that no one could accuse me of making a false statement on December 14th. And so Chesbrough says, I want to tell Nevada that. They say, no, fuck them. And so the defendants aren't in this. They never know it. They're given the documents. They then sign it. They then say, we're signing it because if we win litigation, they can be used. All of that goes to show lack of an intent to defraud, meaning to deceive.
I'm going to sustain the objection. I'm not going to allow the information regarding Chesbrough. By your offer of proof, your clients never even knew that was happening. They're accountable for what they signed at face value, whatever it means. I'm not saying what it means, and you've already got evidence in with Exhibit 7, I believe it is, page 256, a statement of intent during the course of this alleged conspiracy, so it's available for all defendants to use, frankly, as a defense. It's admissible evidence of what their intent was, but Mr. Chesbrough intended something and never told them that. I don't see it being terribly relevant whether or not they knew they were violating the law. And he didn't tell them that. How would they know?
Because there's a statute in Nevada, and instruction says if these people sign something by mistake with no bad intent, it can't be a crime.
Well, then we can address that if it comes up. I'm going to sustain that original objection. We'll come back at 1:30 for continued cross of Mr. Grosz.
So I ask, you're denying the admissibility of the two. I just want to be clear.
Yes, exactly. No, that's a very good point. And yes, I am of the proposed exhibits. One of them, the sworn testimony before the New York bar, and the other one, the proffer of Mr. Chesbrough. Both here say there's a strong question in my mind whether he's truly unavailable. There's a reasonable inference that defense had a good reason to believe that he would be here, but for them to ultimately rely on it, knowing that things and strategies change in cases, the state isn't required to bring forward everybody. I've got some great reservations, but despite that, for the reasons I stated before this, yes, I'm denying going back into those.
Okay, I will lodge them as exhibits.
Absolutely.
Just for the record.
Absolutely.
And the ruling is that they are hearsay and don't fit within the catch-all hearsay exception. Right? Understand?
Yes, and I believe they're frankly also cumulative. I think the relevance is too tenuous when it's information that they don't even know. Wasn't even shared with them from what I've heard so far. So, yes, feel free, we can lodge those as exhibits B I'm sorry, it'd be defense C and D, not admitted, but in the record, for subsequent review of this, if there is any.
Yes, sir.
Okay, we'll take a break. You all are not from the area, so I'm assuming we need at least an hour for lunch. Is that right?
Yes, sir. Is that good?
Okay.
That should be fine, Your Honor.
Okay. We'll come back at 1:30. Mr. Law, I still see you present. You're nodding in affirmative. We'll see you back at 1:30 as well. Thank you all.
Thank you.
All rise, please.
Hey, good afternoon, good to be seen.
Yeah, we're going to start with testimony. I just wanted to make a quick record. Ms. Rice, over the break, her husband was not feeling well. He's, I guess, awaiting a transplant and has some cardiac issues. So she left to take him home to South Tahoe. I don't know whether she'll make it back, but I've talked to the state. They're okay waiving her appearance, especially in light of the fact that we did file a sergeant notice previously waiving her appearance. So I just wanted to make a record that that is why she is not here at this time.
Okay. No, perfectly reasonable. Happy to accept that if you even need your blessing. So, thank you.
Thank you.
Do we have Mr. Law?
I'm just looking.
Feel free. Yes, we just got him. Okay. Yeah, he just showed up and I could hear him. Okay, so Mr. Wright,
Yes, sir.
Mr. Law's here. He can hear us. He can see us. So you're
Yes, sir.
back on.
Is it possible to make a record of who else is on Zoom?
We can. I'm not sure to what end. As far as I know, it's only Mr. Law and Mr. Ford. They're public proceedings. People should be here. It's not set as a live broadcast type of hearing. Ms. Bailiff, who do you see listed as participating by Zoom?
Jesse Law, Courtney Ross, Marcy. It's got a nickname, so I can't read it, and Simba Maruza.
And Your Honor, the last three are AG employees.
So they're all included with the original authorization, so to speak?
Thank you, Your Honor. It's not on there. It's not on the top.
He was on there all morning.
Okay, how do we get this in?
I don't know if he logs back on.
Mr. Grosz, Government Exhibit 6. I have marked and submitted C and proposed C and D, but denied transcripts.
Thank you for noting that. I'll make notes in mind as to what they were.
That's the whole transcript.